Welcome back to the Law News Network. I'm your host, Beth Karras, and I'm in studio here with criminal defense attorney, actually a litigator, civil litigator, and all kinds of stuff as long as it's litigation, Richard Roth, who's Midtown Manhattan based. Welcome.
Thank you, Beth, for having me.
So we've been listening to some replays of Dalia Dippolito because what happens is you can't always be live. We got to find a trial where the judge gives permission for a camera, and August, in my experience, is historically a slow month for trials. Not just here in New York, but around the country. You can't have cameras in the courtroom in New York if there's a jury or if there's testimony. In any event, we're just playing highlights for a couple of days while we wait for our next trial to begin, which we hope will be one in New Jersey. I also want to tell everyone that in about 35 minutes or so, Aaron Keller is going to come in a little early, and he's going to take over from me because I'm going to be the guest. And for a half hour or so, we're going to talk about issues in the Scott Peterson case, because Scott Peterson has a major appeal that is pending right now. You will recall he is the man who was convicted of killing his pregnant wife, Lacey. He was convicted in 2004, but killed her on Christmas Eve 2002, and the 15-year anniversary of that murder is this year, this Christmas. There are lots of specials that are in production right now on many networks, but one is airing now, a 6-part, 7-hour series on A&E every Tuesday night. They started it last week. Episode 2 will be next week. So I will be talking about that because I'm in several of the upcoming specials because I covered the trial, and I've been spending a lot of time preparing for that. In any event, that's at about 1 o'clock Eastern time. Until then, Richard and I are going to talk. We might show you a little bit more of Dalia. So there was an order the other day. Dalia Dippolito, who was convicted at her 3rd trial, her 2nd conviction, right? Now 2 juries have convicted her. The middle trial, the 2nd trial, was a hung jury. And in Florida, unless it's a capital case or murder, it's 6 jurors.
Right.
So the hung was 3-3, actually, very healthy split. So she got a 16-year sentence, and she had a motion for bail pending appeal. Now she's been out for like 4 years, between the trials and with the hung jury and all. 4 years with an ankle brace, a lot of restrictions, but not incarcerated.
Right.
So a couple days ago, the judge denied it. Any surprises there? Isn't it hard to get bail pending appeal?
No. I mean, the judge, she wasn't incarcerated, but she was, if you will, under the supervision with her ankle bracelet of the parole and the police. So they did know where she was, and it's sort of it's a quasi, you're certainly not incarcerated. You can do what you want, wherever you want, but there is sort of a monitoring of you. So the judge sort of bent over backwards. The other thing that's very interesting you just mentioned is that, you have 3 trials, relatively the same trial all times, and yet the second one was a 3-3 split. She's convicted.
I think the prosecution was cocky in the 2nd trial. I know you probably didn't see it because you're a busy litigator. But the 2nd trial, it was a different prosecutor from the 1st trial, because that prosecutor, Elizabeth Parker, is now in private practice. So different prosecutor and different strategy. They didn't call the husband. It was a solicitation to commit murder. They didn't call the husband at the 2nd trial. I think they thought they could pare it down and just do a bare bones presentation. And jurors are like, I'm not so sure.
So the moral there is, if it's not broke, don't fix it.
Yeah.
I mean, they got a conviction, and especially when you now have the testimony, to somehow pare it down, they got bitten. But back to the bail issue, you never know. There is tremendous discretion with a court. The judge can essentially do what he wants when he wants, especially in a state court trial and in federal as well. So they take the bench. They make very, very serious decisions on jail, on punishment, on incarceration, on everything. And so I think the court basically took the 4 years into consideration when it actually
issued
the order and said no. So it's hard to tell.
Well, you have to show likelihood of prevailing on appeal, right?
Correct.
That's the key. Now, let me ask you, because when I had to defend against these applications when I was practicing, it wasn't done before the trial judge. I was at what we call the appellate division here in New York. So, I mean, if sentence has been imposed, Doesn't the trial judge lose jurisdiction? I mean, maybe it varies procedurally state to state.
It does vary procedure state to state. In New York, the answer is yes. In other states, the answer is no. A lot of times, and they both are logical. A lot of time, the theory is that if the trial judge is the one that actually issued the sentence, then the trial judge should be the one to decide whether to stay it, whether to limit it, whether to extend it. The other theory is that this is something that's appealable.
Wait a second. What judge is going to say you have a likelihood of prevailing on appeal because my rulings were bad?
No question about it.
That's why the appellate court should be hearing the argument.
No question about it. And on the one hand, it doesn't make sense logically. However, that judge knows more about this case than any other court, than any appellate court that's going to read briefs. So I hear you. It's almost like saying to a judge, I'm making a motion to renew, and the judge says, I ruled already against you. Why are you making that motion?
Yeah.
But so there are, I would agree with you that the logic dictates more that it should be an appellate court looking at a trial court's decision, because the issue is how likely are you going to be on appeal? And those papers have to go to the appellate court anyway. So it makes more sense to have the appellate court do it, but there is some argument that the trial court judge knows more than anyone else about this case.
True. Now, I wonder if she can renew that, but before an appellate court, or if it's probably fine.
I believe it is appealable. I'm not sure if in Florida it is, but generally it is. It's a decision. It's an order by the court. The case is essentially over. So whether it's interlocutory, meaning that it's during the pendency of the case or at the end of the case, I believe that is appealable. So she may get. There could be two bites of that apple.
So 9 days ago, the state filed a motion in this case for sanctions against the defense. There's going to be a hearing on September 11th. And what they want, and they laid it all out with exhibits in this motion, which is a public document. They want the defense to pay a little over, it's about $1,100 or so, that it costs them to hire an expert to evaluate Dalia Dippolito, because they wanted an expert to refute a battered women's syndrome expert, Lenore Walker, for the defense. They didn't want Lenore Walker to testify, but if she was allowed to testify, Judge, we can refute it with our own expert, but we need to have Ms. Dippolito evaluated by our own expert. Judge ordered it. They set a time and a date. Defense lawyer and Dippolito didn't show. They set another one. They didn't show, and it cost the prosecutor $900 in the expert's fees, like Dr. Anderson, I think, expert's fees, and then like another $285 or something in a few tests that had been administered. Maybe they were administered based on, not an evaluation of her, but whatever he had in front of him that he could use. It seems like a no-brainer, doesn't it?
It seems like a no-brainer. I mean, the court's going to obviously grant the motion. The question I have, I try to look at these things practically. The question I have is, does it make sense? Notwithstanding the fact that they had to go out of pocket $1,100, $900 for the doctor, the other $200. Does it really make sense for the state to actually have lawyers sit there and prepare a motion to recover $1,100 when in time, even though they don't bill their client, in time they're just betting far more than that? I mean, maybe it's sending a signal, maybe they just have a policy.
Absolutely, you can't let them blow you off like that. I'd do it.
I agree with you, but if you flip that over to private practice where an expert doesn't show up, are you going to really spend, you have to prepare a memorandum of law and an affidavit and the exhibits and a court appearance and look at the opposition, deal with the reply, all that for $1,100. I understand why they're doing it.
You're not talking about an expert not showing up there. You're talking about the defendant not showing up.
That's true. I'm sorry, it's the defendant not showing up.
The expert was waiting.
No, I meant the defendant. My apologies. But I understand the defendant was it's inexcusable. There were emails apparently, I'll be there, doesn't show up. And why didn't she show up? There's two theories there. One is that she was just irresponsible. The second is she knew what the result would be. So, we don't know. We do know at the end of the day she was convicted. So I understand why they made that application $1,100, and they are entitled to it, and the judge will grant it. I guess my fundamental problem is looking at it as a business, which the state, of course, does not. Doesn't make sense to have lawyers spend time and money going to court to try to get $1,100. In a criminal case, I guess, yes.
She's doing 16 years, and she has a toddler child, which is really
so sad.
So sad, yeah, that
really
she went
is.
and had this child.
It really
she's
is.
entitled to do that, and the judge would not take that into consideration in mitigation. I mean, he acknowledged it, but it wasn't a factor.
Yeah, you don't know whether she did it because she wanted a child or she did it to have the judge look into that as a mitigating factor. But the sad fact is that she will be in jail unless there's some appeal overturn again for 16 for the whole basically the
her childbearing
childhood.
years. You know, I'm no fan of Dalia Dippolito, but maybe she thought, I want a child, and I'm not going to be able to have one by the time I'm out.
Yeah,
so
it may be. It's just
I know,
sad.
but
The
that's a
kid's
very
gonna be
selfish attitude. If that
very
if that's
selfish,
true.
very selfish. Kid's going to not have a mother growing up.
So let me switch gears. Earlier today, we covered most of the sentencing hearing of a young man in Tennessee named Brandon Banks. He was the third of 3 defendants convicted in a rape at Vanderbilt University. He was a football player. And these men, you know, one carried an unconscious woman to a bedroom, and then, you know, they fondled, raped her. And one is doing 15 years, one is doing 17, and today's sentencing was another 15, which is the minimum, 15 to 25. From what I've read, and I can't purport to be an absolute expert, it was digital penetration, still rape under the law in Virginia. Some, you know, it used to be rape statutes in some places required, you know, genital to genital and not digital or objects, but that's changed in a lot of states.
Right.
There's a young man with no criminal record. His father testified, and the judge even noted, these, you know, all of these defendants were not typical defendants to come before me. But there was a guest here earlier this morning, Bill Stanton, former NYPD.
I know Bill.
And we were just talking about the culture of sexual assault on campuses, which we're, you know, more and more aware of. But awareness is one thing. Doing something about it is another. And I don't know that enough change is taking place.
You know, I agree. The schools generally try to swipe this under the rug because it's just, you know, when you hear of a fraternity incident, you hear of a sorority incident, especially private schools, they just don't want it out there. They don't want that. This publicity is just bad publicity. It makes everyone look down on that school. I don't know. You know, you're still in. We raised the drinking age, but I don't know what to do because there's really, all you can continue to do is provide awareness. Because there are going to be episodes where, not necessarily this egregious, but there are going to be episodes where men and women are drinking and doing whatever, and all you got to expect that friend to just say, stop, don't go there. And unfortunately, on all sides, I mean, you know, these 3 boys are not. They were 20, 21 years old. They knew what they were doing. Yeah, they were drunk, but that's not excusable. So. What's sad about it is, listen, they did a wrong thing, no question about it. What's sad about it is that there's a 15-year minimum because they're not bad kids, but they did a really bad act. And I'm not saying that they shouldn't go to jail 15 years, but if you compare that in our society to other crimes, to a 3-year crime when someone, I don't know, the financial crimes or a 5-year crime, and it's a big part of their lives. And
that's a manslaughter sentence.
It is.
15 years.
It's crazy.
It's killing somebody.
I'm a firm believer. Listen, there are sentencing guidelines in states and the federal government. I am a firm believer that courts should be allowed to, which they don't as much as they should do, be allowed to vary from those guidelines. They should be able to take all the evidence because, as we know, when you're sentencing, the judge gets all kinds of information from the defendant, from the state. You get the parole, you get a report, you get all kinds of reports, you get all kinds of letters, and there should be some way for a court to say, I know it says 15, and what these guys did was it was a heinous act, but they're 20 years old. I'm going to reduce it to 10, or I'm going to reduce it to 8, or I'm going to keep it at 12. I'm not what they did is excusable, but it's just sad that these kids, you know, are going to come out at 30 plus years old.
Well, the judge did say it was 15 on one count and 8 on the other, and he'll be he'll register a sex offender for the rest of his life. But the judge said 15 years is enough for these allegations.
Yeah, when you compare it to the other crimes that are committed, it's a pretty severe sentencing, and that's the only thing you can do. You can give awareness, and you can tell society that this is considered a very serious crime, which it is. A poor innocent girl is drunk, being brought to a bed and raped. So, if there's awareness and knowledge that that such a act can have such negative consequences, maybe that's another way to change it. It's a hard thing to change because colleges, you know, it's just, it's hard, but I think that's how you do it. You make people aware and you let them know you should not go there because not only are you doing something wrong, you're violating someone at a minimum, but you're going to be, the repercussions are very serious.
So drinking on campus, let's move away from sexual assault, but just the drinking on campus is a problem, right? Kids are away from home, and some of the kids are old enough,
Right.
and some are not.
Right.
There is a case pending right now at Penn State, well, involving Penn State students, but it's in State College is where Penn State is,
Right.
and then the courthouse is in Bellefonte.
Okay.
But it's the center. It's Center County. And 17 or 18 students have been charged, and the fraternity, with various crimes, manslaughter being the worst, because of a student who was drinking and he hurt himself and he hurt his head and he kept hitting his head and he got a lot of trauma. And they weren't calling 911, even when one student, they're all drunk and at a party, and it's on video. They had video cameras in the fraternity house, and video only, not audio. And some of the upperclassmen sort of, berated the lowerclassmen who said, no, we got to get him help. He could have major brain injury. Berated him and said, get out of here. We got it under control. Anyway, he died within a few days. It was very tragic. And so the district attorney has brought manslaughter charges against some, not everybody, as well as the fraternity. Are you familiar? With
Yeah,
the
I mean, I am, and unfortunately,
bit.
it happens much too often. It happened in Cornell a couple of years ago. It happens at different universities. What happens is this whole hazing process, where they're joining a fraternity.
That's what it was. It was
many times when they're hazing them, kids just don't think. I mean, I know people who were involved in one not long ago in another school, and they just don't think. And what happens is it's whatever, 3, 4 in the morning, they see someone lying there and they just let him lie there. He's fine. And if someone looks like they need help, they got to say, wait a minute, there's something more important than getting into a fraternity, or, this is my brother, literally, your fraternity brother. And it happens a lot. And I don't know the statistics. I don't know if it's gotten better or worse over the years. It's still a problem. And that's the big problem. It's the drinking, which leads to these kinds of things, and the outrageous requirement that you have to get into the fraternity. I think that's gone down a bit. I think some schools have actually said, listen, we're not doing that anymore, because some schools have gotten in the national limelight, unfortunately. But it's still a problem. It's really a problem.
It's
sad.
enough so that state legislatures have anti-hazing laws.
Yeah.
I mean, there are laws against it, not just
Absolutely.
school rules.
Absolutely,
So,
and that is, again, awareness. You have to educate. When the kids go to college, they have to understand there should be. It may sound crazy, but I think there should be a program for freshman students, part of your introductory program. What types of things that can go wrong, what you should do, what you shouldn't do. It's no different than underage kids having bottles of alcohol. You just got to sort of teach them you can't do that, and there are reasons for those rules. They're not to protect us, to protect you. And I think there should be more awareness on that issue.
Okay, so let me veer off on another topic, but this discussion making me think of it, because some of the evidence in the Penn State hazing manslaughter case involves social media, digital. It's digital evidence. Text messages, things they deleted. There was a camera in the basement where this young man was found ultimately deleted. They're trying to recover it, and they believe that somebody who's already been charged deleted it before the police, got there. I stopped trying cases when I went to Court TV, right? So 1994. So I personally haven't had to deal with digital evidence and social media and how it impacts a trial, whether it's from selecting a jury to the digital footprint that the witnesses have or your clients may have. But another guest who was here a while ago said to me, one of the main requests he gets from his clients is how to erase a negative digital footprint, like something that may have happened years ago that's affecting them in the future in their efforts to try to get a job. They did something stupid in college. They paid their debt to society. It shouldn't continue to haunt them 10, 15 years down the road, but it does. So can you talk a little bit about your professional experiences with this?
Sure. First of all, as far as trials go and litigation goes, until that litigation has been commenced, or until you have notice of a potential issue arising, then you can naturally, in your normal course, delete emails and delete things. If it's your normal practice, that's what Arthur Anderson got in trouble with years ago, which led to its demise.
But
as
deleting
far as,
doesn't mean it's gone forever.
it does not mean it's gone forever. But as far as trying to get rid of the bad stuff on Google, if you will, that's out there, which is a credibility issue. There are companies out there which actually will move down, like a video of, let's take the Penn State kids. That's got, if you Google Penn State and drunkenness, it's going to be right up there. And it's not going to happen today, but over the years, there are companies out there that actually, through algorithms, move that down so that you, if I Googled your name, and you were involved in it 5-10 years from now, they put other things on there to make it not as, if you want to apply for a job. You know, one of the kids, let's assume one of the kids is indicted and he's tried and he's innocent of the crime in Penn State, hypothetically. And yet, if you Google that kid, if you want to apply for a job as an accountant or a lawyer, you're going to see, first thing, Penn State charged, right? So there are companies out there that actually go through, in algorithmic form, ways to move that down off the first page of Google.
So it's not up at the beginning of the search and you might say, well, I can't find anything, everything seems to be unrelated, and you stop looking.
Yeah, and I've had clients who have said, listen, especially in the securities industry, and everything in the securities industry is public, there's FINRA, and there's something called broker check, and I've had a lot of clients where they may have had something against them, either a charge or actually a ruling, and it was 15, 20 years ago. You Google the name, boom, they're up there, and they're saying, I can't get any business. So they actually can go to companies. It's not cheap, but you can go to companies to move that off the first page. Because at the end of the day, you're not looking at the first or second page of Google when you look for someone. You're on the first page, you're looking
really,
for...
I always figure if I'm on by the bottom of page 2, if I haven't found what I'm looking for,
Right.
because at that point, you know, you see bolded, if it's a person's name, it's a first name for somebody else, the last
Right.
name on somebody else, and it's
Right.
like, okay, I'm done. It's really in the first page or so. So when you say it's expensive, like what are you talking?
Well, I mean, so the reputational companies. I actually was involved in one a couple of years ago. Which came out of Great Britain. They were big in Great Britain. They came to New York, not successful in New York. They're still in Great Britain, and they are it could be in the tens of thousands of dollars to actually hire a company. They're reputational management companies, to hire a company to get the bad Google off your reputation. There are.
Tens
it's no different than.
That's crazy.
That was crazy.
If it's one entry.
But that one entry
is everywhere.
It's everywhere.
It's everywhere.
You Google it. You can Yelp it. You can Yahoo it. You can any Bing, and you're going to be up there. So there are companies out there, and it's not cheap, but it's necessary, because it hinders that person's ability. It's a scar. It's a scar. We didn't have that back in the day when you were trying cases. You didn't have that. Now it's really a scar. The first thing my clients worry about, and many times people come to me to get someone else bad press, because so a lot of times
you say no, don't you?
Of course I say no. I say no, but if a complaint's filed, boom, it hits the press. Yeah. So it's used both as a shield and a sword now, but it's a very different animal. So I have a client now that's involved in allegations of rape, which allegedly never happened. But the concern was, if an indictment comes down, it's going to ruin his business. Now, an indictment had not come down and probably won't come down, but just the thought of an indictment coming down can just destroy you, because it's not. You don't have to go to the courthouse anymore and look for it. You can literally Google the name and it's at your desktop. So it's scary. It's a very different world than it was when I tried cases back then too, 15 years ago, 20 years ago.
So what about selecting juries? How do you use social media to help you ferret out jurors? Because I've seen mistakes in trials because they didn't do enough. It's
funny, the traditional way, I just tried a case 3 weeks ago in Queens, and the traditional way was you look at the person walking in. Are they reading the New York Times? Are they reading the New York Post? Are they, how are they dressed? What's their demeanor? And you'd sort of try to figure out where they fit in your sort of pool and your spectrum. Now, you get their name and you go into their Facebook page, you go into their LinkedIn page, you Google them, you try to find out anything and everything
Twitter
about
handle.
them. You can tweet them, you can their Twitter handle, and you can really learn a lot more. So these jury consultant companies that had very little facts upon which to draw information from now are doing very well, because they can say, listen, Mrs. Smith is a tough name because it's a common name, but Judy Smith, who is potential juror number 3, let me give you a dossier of who she is, where she was raised, how many children she has, and you can do all that now. It's really, what's out there is both beneficial for like jury consultants, but it's a little scary, because you know, your record could very well be page one of Google, and you know, and anything you do. So it's an interesting balance when you're handling it on my end, because you do worry about that. I have clients that do say, maybe I shouldn't sue, or maybe if I'm sued, my bigger concern is not that I'm going to lose the lawsuit, it's that I'm going to lose all that other business from what's on Google. It's a very different world now. It really is.
And what about jurors? Do you find that jurors violate the admonitions? Because admonitions now include all kinds of things they didn't include when I was trying cases.
Right.
Like, and you can't, you know,
You
get
can't
on
tweet.
Facebook and Twitter and LinkedIn.
No, you didn't have
and
it
all
in
that.
1994.
Right. Yeah, you didn't have that. Right. I mean, do you find jurors are abiding by the admonitions?
I think they are. I think jurors, it was interesting, my jury pool in Queens, there was not one person who had previously been a juror, which I found fascinating. But I think they are. I think that they, a lot, especially when you haven't been a juror before, you're like, you know, what can I do, what can I not do? Maybe I should err on the side of just not doing anything. So I think they generally do. Once it's over, it's free reign. But I think they don't want, they understand generally that there's a system, and they are a piece of the puzzle, and there's a puzzle, there's a piece of the puzzle, and they don't want to do anything to, you know, ruin it. There are jurors, every once in a while we hear them in trials that you broadcast, that, you know, go beyond and do something stupid or do something public to essentially either have that juror dismissed or have the entire jury thrown out. But it's not, it's more the exception than the rule.
Interesting. So I want to thank you for an enlightening discussion today. It was very nice. It was
Thank
so
you
nice
for
to
having
meet you.
me.
We had never met before.